SJC-13329, Commonwealth v. Michael Van Rader, Jr.
Okay, anyone?
Good morning, and may it please the court. John Warren on behalf of Michael Van Rader. For two reasons, we are asking that you reverse the motion judge's denial of the motion to suppress. First, when Mr. Van Rader and the juvenile were stopped on a path in Jamaica Plain, there was no reasonable suspicion for the stop. Not where the stop was based on a bare bones and generic description. Two guys wearing hoodies on bikes, that was the dispatch, and not where it was conducted nearly a mile away, and not where Mr. Van Rader and the juvenile did not even match that bare bones and generic description. Second, the stop violated Mr. Van Rader's equal protection rights, where a review of the FIOs of the officers who conducted the stop over 18 months revealed that 90% of the individuals, those two officers...
Did the Commonwealth rebut that evidence?
No.
Why not?
Well, what I would suggest is that the statistics in this case, and I'm going to get to that, but essentially 90% of the people that...
I get the statistics. Answer my question.
So what I would suggest is that the statistics in the circumstances of this case, where the officers had discretion based on that generic tip, based on it being a mile away, considering the statistics, that Mr. Van Rader established a reasonable inference. And that at that point...
Can the same evidence that supports reasonable articulable suspicion satisfy the equal protection inquiry?
What I would suggest is that the best articulation of how the Commonwealth would rebut it is from Long, and what Your Honor said in Long was the Commonwealth needs to respond to all inferences and all the facts. And so what I would suggest is once the defendant has met that threshold of reasonable inference, the Commonwealth needs to take it apart and grapple with not only the facts of the stop, but also with the statistics at that point.
So assuming they don't attack these stats, they can marshal the facts of the stop to say there was a race-neutral reason to stop, correct?
I do not think that would be sufficient in rebuttal. Once the defendant has established a reasonable inference, I think they need to grapple with all of the inferences and all of
Let me give you a hypothetical. These 90% police officers are walking the same beat. They walk past a house. They hear a scream from the house. Out of the house bursts a suspect carrying a bloody knife, and they tackle him. Is that okay?
What I would suggest is that it would be very difficult in that circumstance for the defendant to...
These are the 90% per people, right? So you raise the inference.
Right.
Has that been rebutted?
What I would suggest is that it would be difficult for the defendant to establish a reasonable inference that that stop was based on race. And I think...
So the same facts that support the stop can be used to rebut the inference, at least in that hypothetical.
I think that, and I don't think there's law on it, but I think in thinking about that, that's what makes sense. What makes sense is that...
I get what we said in Long, that you have to grapple with all the factors. But can it be that, just like in jury selection, there is a race-neutral reason, and the judge can credit or not credit, and here Justice Krupp looked at it and said it did rebut the inference.
What I would suggest is that the way this court going forward should look at these pedestrian stops is to think of it on a continuum of discretion, from more discretionary stops. I would put Mr. Van Rader's case in that position all the way to Your Honor's hypothetical. And that's why I think a totality of the circumstances test makes sense with respect to equal protection pedestrian stops, because it's going to give judges the tools of figuring out where along that continuum the stop lies, and that the statistics should be considered in that context. And there's language in law about statistics being considered are always considered in context. And so I think in Your Honor's hypothetical, the statistics in that context are not going to give a defendant a great argument as to a reasonable inference of selective enforcement.
That's why I think these two cases are harder, because they involve, reports of gunfire and police response, as opposed to, as you've probably seen, someone who's on the street trespassing, or a much more discretionary action where they stop and frisk.
Right. There's no question about that. I mean, we could think about a hypothetical involving...
And I get it. The case is the case, and you raised Long, and Judge Krupp agreed with you.
Well, what I would say
They
is...
agree with you that Long applies to...
Right. And I think that, to Your Honor's point, we could come up with a hypothetical based on a trespass case. That's different than this case. However, I would suggest that although it is a serious incident, and although that should be considered not only for reasonable suspicion, but also probably for equal protection, it's the discretion that the officers had in this case. And that's based on the generic tip, which was essentially two guys wearing hoodies on bikes, which these two kids did not even meet because they weren't on bikes.
So you basically, Justice Graziano sort of just had the same comment in many ways that you just said in footnote 11 in Long. If you remember, that's the OUI footnote, where the inference, it draws against the inference.
Right.
So what's interesting about what you said is that when you look at the circumstances on the reasonable inference, and if the reasonable inference is satisfied, then when you get to the non-exclusive Long factors, which would have to be recrafted to some extent for pedestrians, you look at the circumstances. So if that's what footnote 11 suggests in Long, and if that's basically the situation, if you took the facts of DePino with the police shooting and close by and the specifics of the description, on the inference and or on applying the non-exclusive factors, how does it come out?
Right. I think, I think it goes back to that continuum of discretion. And to Justice Graziano's hypothetical, when someone's running out of essentially the police officer observes a conduct, that the statistical weight is going to tell you less because there's less discretion in that stop.
Should you even get discovery in that context?
You
got discovery in your case, but
right.
We're going to turn every case into, basically an enormous discovery issue. But do you get discovery when, I had the same concern that, the question that Justice Graziano raised. So the guy's running out there with a bloody knife, and they tackle him, and it's Springfield, the last case. Do you get discovery in that case? Because they may have implicit bias, these officers, or they may have actual bias, but that's not why they tackled the guy.
Right. I think, and again, this is not a discovery case, but I think it should be a low threshold, and that.
But we're going to have to. There's going to have to be some tinkering of Long at every step, isn't there? Because this is different. Because we're not dealing with car stops and the fact that there's so much discretion there. Maybe the FIOs are that way, but the Terry stops are the hard issue, We're going to have to make changes, aren't we, in all three levels of this?
I think the articulation of the discovery standard in Long would apply to this situation, which is material, and it's essentially material.
It's Rule 14.
It is Rule 14.
So Rule 14. So apply it. Okay, well, it doesn't pay here because it's not a discovery case. But
Counsel, if Justice Tasker is finished with that question,
I'm
I'd
done.
like to ask you about the FIO report. There are some in our record. The expert analyzed these FIO reports, and she's just looking at a set of reports which had ethnicity and a narrative, so she could determine whether the search or the frisk of the person or the vehicle so she could make a determination about that. Those are submitted, I think, but were there any other FIO reports that she looked at that are not in our record?
So I don't think that the full FIOs are in the record appendix in terms of that she relied upon.
Right. Are they?
They were an
they
exhibit at the
submitted
hearing.
to the trial court?
Yes. On a CD.
Do the FAOs include, I don't know, obviously the field observations, but do they include non-constitutional deprivations in the FIOs? Meaning if they go up to a kid on the block and say, hey, who are you? Who's your buddy? And they
Yes,
write down.
Yes, I think FIOs would include both situations, both an actual Terry constitutional stop and a non-Terry.
It doesn't really align with the long, does it? Because long, a traffic stop is always a constitutional deprivation.
Well,
you need justification to stop a vehicle.
I would push back on.
You don't need justification to walk up to a kid on the street and say, hey,
right.
You're from around here. Who's your buddy?
I would push back on that and say it doesn't need to be a constitutional stop to raise a separate equal protection issue. These are separate doctrines.
Selective law enforcement.
Well, I think selective enforcement, it doesn't need to rise to the level of a constitutional moment like a Terry stop. And I think...
Was that challenged below, by the way, the use of the FIO versus the use of arrests?
In this case, our position was always that when the officer got out and said, hey, you guys, basically, that was a stop. And that's essentially what Judge Krupp...
You've probably litigated it a bunch of times. Hey, you guys, or can I talk to you? That's sometimes a stop, sometimes not a stop.
Right, and Judge Krupp found it to be a stop. The Commonwealth has conceded in this case it was a stop. And I would suggest...
But I meant the FIOs, not in this case.
Oh.
But it wasn't litigated below, right? As far as the statistical model and the use of FIOs versus arrests?
In terms of in the data that Dr. Fowler analyzed, I don't think there was a distinction made. And I don't think I don't really know that distinction is that important, frankly. And I think, if the hypothetical was that there wasn't a constitutional moment in terms of a Terry stop, I do think unconstitutional or police conduct, police investigation, that's not on equal footing, that would violate protection. And I was
to your point, we did say you can look at FIOs in long, so that Judge Krupp was just doing what we told him to do, right?
Right. I did want to talk a little bit about the reasonable suspicion argument here, and I'm happy to jump back to the equal protection argument. But what I would suggest is that this case falls in the footsteps of Warren, Cheek, and Menaeus, and that's based on the generic description. And that's really how this case should be viewed.
How about Evelyn?
And that this case should be distinguished from Evelyn and Karen K. And the reason that those two cases are different is because in those cases, the officers are observing the individual and the things that the individual is doing. In Evelyn, it had his arm close to his waist, observed an object consistent with the size of a firearm in that person's pocket.
Same time-space issue on Evelyn versus in this case, though, right?
Very similar. But it's those individual observations of that person, And that's what the Karen K decision, I think, is along similar lines, where it's the officers observing that particular person and taking their movements to be suspicious based on their own training and experience. And in this case, there's none of that. In fact, these officers were trained in that armed characteristics of a trained gunman, and they didn't see any factors that these two kids walking in Jamaica Plain.
So I think what you'll probably hear, based on the Commonwealth brief, although they didn't put it this way, is that you have a continuity. What's his name, O'Loughlin, I think?
Right.
So O'Loughlin is sort of the person who transfers information, in that the bikes become the linchpin in order to be able through O'Loughlin to transfer information. So I guess my question for you is, why are they wrong?
So I think Officer O'Loughlin's observations are very minimally relevant. He's a half mile away. He's 300 feet from an obstructed away viewpoint of the path. And what he relays is that he sees two guys on bikes. That's basically what he sees.
Is it some of
But-
them look exhausted?
He says they look tired.
Pedaling, yeah.
Right, pedaling slowly as if they're tired. But he doesn't know that those are the shooters. He's just seeing two guys on bikes a half mile away.
He's a conduit. I mean, I get, I'm
That-
not sure they
and-
phrased it that way. He's a conduit.
And
for
I would
information.
push back on just what I would suggest is sort of a post hoc looking at this. Like, it's obvious he was going to see them. It's obvious they went that way. It's obvious that the two guys that were stopped were the guys that Officer O'Loughlin saw. And because I think it's speculative to say that Officer O'Loughlin was seeing the shooters, and I think it's speculative to say that the people that were stopped were the people that Officer O'Loughlin saw. And part of why I say that is because Officer O'Loughlin's radio description, real-time radio recording, he says the people he saw were in a black vest and a black jacket on bicycles. The people who are actually stopped are wearing hoodies and they're walking.
I thought the description was hoodies or sweatshirts.
That's what Officer O'Loughlin testified to, but his real-time radio recording, which is in the record,
Judge Krupp credited his testimony about hoodies or sweatshirts, right?
and I would suggest that's
Erroneous.
clearly erroneous, where you have his real-time actual statements as to what these two people are wearing, which is pretty specific, 300 feet away.
And I assume you impeached him with that.
Right, and he admitted that that was him on the radio, and that's in the record. He did mark.
The nature of the crime cuts against you under Depina and Lopes, right?
Right, and I think Menaeus is clearly establishes that that's a factor, and there's no doubt it's a factor here. Another point I wanted to make.
I'm sorry, I'm, just because you're over, is the point in your brief?
Not specifically, what I would just say, if I could, Your Honor, to Karen K, because it was a question that was asked at Karen K, and I know that case just
Yep.
came out.
Yep.
Was one of the questions was, and it might have been Justice Wendlandt, was what's the denominator here when we're looking at the officers making calls on the street? I believe it was Your Honor said, well, what's the denominator? We know how many firearms they're seizing, but we don't know how many stops they're making. And the record is clear on that because one of the officers testified about how many pedestrian stops he makes and car stops he makes a month. When you do that out, it's about 660 a year, and he estimated he makes about one gun arrest a year. And what I would suggest is that on both the reasonable suspicion and equal protection, this case is not just about the 1 out of 660, it's about the 659 other people who, most of whom are black, are being stopped. That's really what this is about. And I think this court, in terms of search and seizure, Article 14, this court has established extremely clear, well-developed rules that everyone, practitioners, we know we're going to get an Article 14 Fourth Amendment hearing. We know the doctrine is well-developed, but with respect to equal protection, it's underdeveloped and it's not being discussed in courts. And I think to the extent that this court can further that doctrine on equal protection, to the extent there's inequality in our criminal justice system, that's the answer, and we can look back and say we tried.
Okay, thank you.
Thank you.
Okay, Attorney Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth. Joining me is Assistant District Attorney Michelle Slade, the trial prosecutor on this case. I'd like to begin with the question posed at the beginning of Attorney Warren's argument of whether or not the reasonable suspicion the factual basis of reasonable suspicion can serve as the rebuttal of a reasonable inference of racial profiling and argue that it can, and in this case, it more than sufficiently did. To the extent that this court would like to hear more about the facts surrounding the reasonable suspicion in this case,
Forgive me if I don't have it right, but do you concede that long applies to pedestrian stops?
no. Long applies solely to motor vehicle stops for traffic enforcement, civil motor vehicle violations.
Why?
Because, as the court said in the decision, it is nearly impossible for drivers not to violate the law. And for that reason, the discretion that's in the hands of police officers when they're making traffic stops, motor vehicle infraction stops, ought to provide to defendants a lesser burden for showing unequal protection of the laws. So it is unique to traffic stops because everyone is violating.
Well, everybody walks down the street too.
And they are not stopped.
Well, when you read the stats of these police officers, it's kind of striking, isn't it?
Well, the distinction.
And if Judge Krupp didn't say it applied, we wouldn't know that these people would be, these individuals strike that black people in this neighborhood were being pulled over at alarming rates.
And the important distinction would be that a motor vehicle stop is constitutionally supported. It is a legal mechanism for officers to seize a person if they are violating traffic laws. And because officers hold that authority for enforcing traffic laws,
But don't
it's very different.
Don't they hold the authority to get out of the cruiser and say, hey, you, come here.
And that would not be a constitutional seizure.
Hey, you, stop, come here. That's a seizure.
And that's certainly different.
Which way does your point cut, though? Because at least with the authorization rule, something's happened to justify the seizure, and then there might be a long issue that gets litigated. So, but there is some justification.
Yes.
Whereas for an FIO, you don't need anything. So my question is, which way does your point cut?
FIOs may not be supported in the way Your Honor is suggesting. FIOs also, though, may not be a stop or an interaction in any sort of sense. The way that I think, and this is potentially a side issue, but the way that it's been being discussed with discovery issues so far today, they are not always documenting the stop or personal interaction with people. They are, as the O stands for, sometimes simply observations. And if I may ask Your Honor to clarify your question, what do you mean by how does it cut in terms of whether or not long should apply?
Yeah, so your point is well taken, that with a motor vehicle, you could just sit anywhere and wait for somebody not to stop fully at a red light or not signal soon enough before the turn, so you can pull anybody over. And you're saying that there's been some seizure there. And you're saying with an FIO there isn't. And I'm saying, well, if you don't need anything for an FIO, what's the argument? Isn't that an argument that maybe we should be concerned about racial profiling even more? Questions, not an answer.
Well, the concern is certainly there, but I think the question in the context of these cases, as we've cited in our briefs, is there is a mechanism for defendants to prove unequal enforcement of the law through LORA and benitence. Long is not the mechanism for doing so.
Well, long may not be the mechanism for doing so for I guess, is there a distinction between Terry stops outside of the car context and FIOs? Because it seems like long makes complete sense for FIOs. It's very, and just in response to Justice Lowy, there's even more discretion there. You can do it for anybody for whatever reason, but your case is not a FIO case, it's a Terry stop case. So maybe long doesn't apply as neatly to Terry stops out of the car as it does to FIOs out of the car. You know, FIOs are, sounds like classic equal protection violations. You know.
And at the risk of misunderstanding what the court is asking, I'm a
My
little
question's-
confused.
My question's simpler. My question, put FIOs aside, because I think that's a loser for you, for the reasons that Justice Lowy just said. But a Terry stop outside of a car long may not fit neatly into that. You may need to modify long to make it work there. Equal protection clearly applies to Terry stops out of the car. The question is, does long apply neatly to that circumstance? It may apply neatly to FIOs, but it may not apply as neatly to Terry stops, right?
It does not. And because there is not the assumption that similarly situated people are
There's not as much discretion. I mean, discretion is
Correct.
cabined by reasonable suspicion, and it's not like everyone's driving a car. You know, your case here isn't a great one, but you can see, like in the previous case, the guy's got his arm extended, like where he looks like he's holding a gun, like a Dapina type situation. You know, it's a different calculus maybe than Laura and Long are. You know.
It certainly is, because there's no, there isn't a presumption that similarly situated people are behaving in a way that rises to the level of reasonable suspicion.
Statistics would say otherwise, though, right, in this case?
They wouldn't. And to the court's earlier question about whether or not the Commonwealth attacked the statistics specifically and rebutted the statistics, we did. The Commonwealth cross-examined, the expert put its own report into evidence and made the point that the categorization of discretionary stops was not.
But you're bound by what Judge Krupp found, correct? Just like you get the benefit of his reasonable articulable suspicion findings, you also get the sword of his findings on discriminatory stops, correct?
And to the extent that he did comment on that, and I hopefully made this clear in my brief, he does make that observation that the officers have stopped significantly more people of color than otherwise. But he purposefully says, I'm not going to look into that anymore because the Commonwealth has rebutted any inference through reasonable suspicion. He does not engage in actual analysis of whether or not those statistics hold up against the Commonwealth's rebuttal of it.
I read his findings, but he doesn't make findings, it was the 90%, it was this, it was that, correct? I haven't read the transcript yet, but.
No, he makes a generic statement.
All right, so what's the remedy to this then? So there's a generic acceptance of the statistics. What's the remedy on equal protection grounds? No, what do you think the remedy should be under equal protection, if not long?
So the remedy after a judge makes the initial finding of the validity of the statistics is to allow the Commonwealth to rebut. Is that Your Honor's question? The judge needs to open the door for the Commonwealth to rebut.
No, if you're saying that long doesn't apply, what should we do about this then? How do we address racially motivated stops if long doesn't apply?
Racially motivated stops based on reasonable suspicion?
Based on, in this case, the judge found a disturbing pattern of racially motivated stops. And I'm asking you, and I think you have to concede, that Article 1 and Article 10 would give a defendant the right to a selective prosecution argument, correct? challenge.
Yes.
Right. Then what do we do with that? What do we say the remedy should be?
The remedy is well, I'm not sure if this is the remedy, but it needs to be analyzed under Laura and batons. It needs to be looked at, not,
Well,
needs to be looked
normally,
at
if
in
there's an
terms of-
equal protection violation, the remedy is dismissal, isn't it? Whereas in the traffic stop situation, the remedy has been altered for suppression, the application of the exclusionary rule.
that is correct, and
You want us to dismiss these cases?
So you want us
No,
to dismiss if there's an equal
no, I
protection?
do, no, what I was about to say is though that may be an accurate statement in terms of how the law is applied, that is not accurate as to what should happen here or what the record is here.
Well, I take you disagree with the remedy, but we have to do an equal protection analysis, right? And now we have discovery that indicates that these officers have they either have implicit or explicit, some kind of issue has been raised about whether there's implicit or explicit bias on their part. But at the same time, you have shown that, but then what makes it hard for you is we also have a pretty discretionary decision. It's the opposite of the hypothetical that Justice Gaziano raised about the bloody knife. Judge Krupp has given you some good analysis there, but a lot of discretion has been exercised there. Don't we have to, I'm just trying to understand what the structure, when we deal with discrimination in the employment context, we have these three-part processes. We've created one long for auto stops. And I think we're asking you, if long doesn't apply, something has to apply. There needs to be an analysis that takes us through the next steps. An inference has been raised about racial bias. At the same time, there's support for reasonable suspicion. What do we do with the conflicting things here? How do we take it to the next steps? That's hard. Because it's not just long doesn't apply. You need to help us resolve the tension between there may be a legitimate police action here, but there may also be illegitimate police bias involved. That's tricky.
And if I may answer in two parts, both in the way that Judge Krupp analyzed and decided along those lines, and then to your Honor's point about the discretion involved in this stop. Judge Krupp, in the beginning of his rulings of law, makes the note that the police making the stop had a history of disproportionately stopping people of color. But the Commonwealth had demonstrated that the decision by the police in this case was not made because of any improper considerations of race. So though his findings and rulings may shortcut the full equal protection analysis in terms of the steps that have been laid out in the case law, he is bypassing aspects of that analysis by coming to the conclusion.
Right, but Mr. Warren raises a very good point at the end. Like, we have to provide a more robust way of analyzing that tension going forward, because Article 14 and the Fourth Amendment have very good guidance. Long has provided that guidance in auto stops, but we now have this different situation that we have to flesh out, don't we? Yeah. And
There may be different
this
situations.
case presents a real tension because the FIO stats are concerning, at least to Judge Krupp. I haven't read those stats, and I have no idea whether they really show that FIOs are performed in a biased way, but not Terry stops. I just don't know what they show.
Agreed, and that is a flaw, maybe a flaw in his rulings, but because he bypasses those steps and those analyses, as I mentioned. And at the risk of sounding overly practical, but the court has been engaging with the discovery aspects related to these cases. In a case where it is a Terry stop, or it's different than this case, I'd imagine some other sort of hypothetical, there is discovery that would be more narrowly tailored to a defendant's stop and situation that could help that could lead a defendant to meeting its inference, their burden. That said, the breadth of discovery that Long allows under Rule 14 would be different than those scenarios. Those scenarios, the relevance that needs to be articulated is that there's a factual basis of believing that there was racial profiling based on the context of their case and the discovery being tailored to the context of this case. The way that Long is being applied in situations outside of a motor vehicle context creates the lack of logic in terms of somebody being stopped for suspicion of committing a shooting moments before versus a series of people who have been pulled over for highly discretionary, non-safety concerning motor vehicle stops. So
Just sort of take your position as cogently as it can be taken.
yes,
You're saying because of that difference, all three prongs have to be satisfied for selective prosecution instead of eliminating the first two like Long does.
yes,
That's your position, right?
yes.
And what we need to decide is whether or not, no, there are similar animating concerns involving pedestrian stops. I mean, I don't mind to be too cogent, but that's what you're saying.
Yes, and the Commonwealth is not suggesting that there are not circumstances in which a pedestrian stop wouldn't, or I will not say that that is an absolute bar. There are pedestrian-related stops that may imply traffic enforcement, as the point has already been made today. Jaywalking.
Protection never goes away.
Of course.
It's just whether how it's proved has to be proven, and you have a different view than the defendant, and that's what
Yes.
we're going to take under advisement.
I think that's well said.
I didn't mean it as.
Thank you very much.